You're welcome to this presentation. My name is Akim Olajide Bello. I'm of the Department of Public Law, Faculty of Law, University of Lagos. In the last presentation, we looked at the law relating to attempts, and we looked at the elements of the offense of attempt. We looked at the statutory provisions governing attempt. We looked at judicial decisions on attempt, and we looked at the tests that the courts have advanced to help us determine when we can say confidently that an offender has committed the offense of attempt. Today, we want to examine another preliminary or inchoate offense, that is the offense of conspiracy. So I'll project my slides now, and then we can take it on from there. So I believe you can see my slides now. The learning objectives. The objective of this lesson is to ensure that students understand the ingredients of the offense of conspiracy, which includes the agreement, the parties, the unlawful purpose, and the issue of impossibility in conspiracy, as established by statutory and judicial authorities. For the lesson outcome, at the end of the lesson, we expect that students should be able to explain the ingredients of the offense of conspiracy, which includes the agreement, the parties, the unlawful purpose, and impossibility in conspiracy as established by statutory and judicial authorities. And we expect that students will be able to use the knowledge of the ingredients of the offense of conspiracy to answer problems or essay questions on conspiracy in the event that you are faced with a problem question or an essay question on the offense of conspiracy in the exam. We expect that you should be able to use the knowledge you have acquired to answer the question. Now, meaning and policy justification for conspiracy. Conspiracy is not defined in the criminal code, and it is also not defined in the penal code. In the case of Majekodumi against R, 1952 14 Waka, page 64, the court adopted the well-known definition of conspiracy by Willis J. Imolke and R as follows. A conspiracy consists not merely in the intention of two or more, but in the agreement of two or more to do an unlawful act, or to do a lawful act by unlawful means. So long as the design rests in the intention only, it is not indictable. When two agree to carry it into effect, the very plot is an act in itself punishable if for a criminal object or for the use of criminal means. So a conspiracy consists not merely in the intention of two or more. Yes, intention is important, but it is more than that. It consists of the agreement of two or more to do an unlawful act or to do a lawful act by an unlawful means. So for as long as the design rests only in intention, then no offense is committed. But when the two agree to put their intention into effect, then we reach the level of the offense of conspiracy. When they agree, when they form an agreement, when there is a consensus addendum, a meeting of the mind of the parties to carry out an unlawful act or to do a lawful act by an unlawful means, then the offense of conspiracy is constituted. Now, the big question is, what is a policy justification for the offense of conspiracy? And I usually, explain the policy consideration by, illustrating it with the September 29/11 incident in the US, when Osama bin Laden and his co-conspirators unleashed a terrorist attack on the US. Osama bin Laden, leading a host of other conspirators, conspired together to hijack planes and use planes as a weapon of mass destruction. So Osama bin Laden, leading a network of other terrorists, hatched a plan, hijacked two planes. One of the planes was flown by the terrorists into the World Trade Center in New York. Another plane was also hijacked, but some of the passengers on board that second plane were able to engage the terrorists, in a scuffle that resulted in the plane not hitting its target, but fortunately crashing on grassland somewhere in, around Washington, D.C. So this was an incident that resulted in the death of over 3,000 persons. Now, it is not possible for one individual to carry out a terrorist attack that will result in the death of over 3,000 human beings. The massive result in terms of death accomplished by that attack was only because there was a meeting of the minds of several conspirators, across geographical boundaries. Osama bin Laden himself was probably in one of the, the mountains of Afghanistan, between Afghanistan and Pakistan. That was his natural abode, He was able to hide in the mountainous region away, from American CIA, another Secret Service hunting for him. But he was able to use his network of terrorists to hatch such a devastating plan. Because when two or more human beings put their minds together, their intellects together, their resources together, they are able to hatch and produce, and carry out crimes with such devastating consequences. That exactly is a rationale behind the offense of conspiracy. Once persons have an intention and they've agreed to carry out their intention, that mere agreement alone is a serious threat to society. Even where they have not carried out their act. For instance, if Osama bin Laden and his group were intercepted after they've, formed the agreement, after they've agreed to carry out their plan, that alone is sufficient for criminal liability. The law does not have to wait for them to carry out their intention. And that is the rationale for the criminalization of conspiracy. When persons have an intent to commit an offense and they've agreed to commit that offense, the moment they agree, the moment an agreement is reached, the offense of conspiracy is constituted, because at that level, society is exposed to very serious crimes, which is a product of the meeting of minds of more than two persons. So that is a policy behind the justification, the policy justification for the offense of conspiracy. Now, we want to look at the ingredients of the offense of conspiracy. The first ingredient is the agreement. The essence of conspiracy is an agreement between two or more persons to do a prohibited act, to do an act that is prohibited by law. Conspiracy is complete as soon as the parties agree without any further steps. I've already explained that. Once the parties they have an intention to commit an offense, and they move beyond the level of the intention to agree, there is a meeting of the minds. Their minds meet to carry out the act. Then at that point, the offense of conspiracy is complete. Even if they later change their minds, or for one reason or the other, they did not go ahead, to carry out their intent, that offense is already committed. So conspiracy is complete as soon as the parties agree without any further steps. And you can see the authorities for that proposition: Jovens and the state, Okeke and another and the state, Posu and the state. These are cases of conspiracy which establish the fundamental principle that conspiracy is complete as soon as the parties agree without any further steps. So unlike in the offense of attempt, the offender has formed an intention to commit an offense, and he has moved beyond the level of his intention by manifesting his intention by overt acts. directed at carrying out his intention. In the case of conspiracy, there's no need for the offender to begin to carry out, to take any step in furtherance of their intention. All that is required is that an agreement has been reached. There is a consensus ad idem. Once that is done, then the offense is committed. Where one or more of the parties involved in an alleged conspiracy merely entered into the agreement for the purpose of procuring incriminating evidence against the defendant who instigated the conspiracy, there is no conspiracy. Now, in this interesting case of State and Otu, the main offender wanted to eliminate a witness, and he procured others, to help him kill that witness. But unknown to him, those others that he procured were not actually interested in carrying out the act. And they eventually informed the police, and the police arrested all of them and charged them to court for conspiracy. But the court held that the others who only played along for the purpose of, enabling evidence to be gathered to incriminate the main offender who wanted to kill the witness, that there was no conspiracy between the mastermind and the other persons who played along with him in order to gather incriminating evidence, because there was no meeting of the minds. Their minds did not meet with him to carry out the intention to kill the innocent victim. If their mind has agreed with him, then they will have gone ahead to carry out their act. But they merely agreed with him for the purpose of setting him up and being able to gather incriminating evidence to hand him over to the police. So the court in this instance said that there's no conspiracy between the person who procured them to kill the witness and the others. And however, in this instance, the court convicted him of the offense of attempting to procure the commission of an offense. So there was no conspiracy in that instance. The agreement may be expressed or implied, direct or inferred from evidence. Usually the evidence of conspiracy is not usually very direct. It's usually inferred from the evidence, although there are some instances where the evidence may be inferred, from both express evidence or inferred from the evidence. If, for example, you have a situation in which a mastermind is trying to recruit other terrorists into a group, and the law enforcement authorities are able to intercept email communication between them, they may be able to piece the email communications between them together to establish the fact that there is an inference of an agreement between the parties to carry out the act. So the agreement may be expressed or implied, direct or inferred from evidence, although the usual case is that it is usually inferred or implied from evidence that law enforcement authorities are able to gather. You can see the case of Shodia against the state and Badamosi against the state. If the agreement cannot be inferred from the evidence, then there is no conspiracy. In this case, the offender was said to have run away as soon as he sighted law enforcement officers approaching him. And the court said that, well, the fact that somebody runs away from seeing a policeman approaching him is not necessarily evidence of a conspiracy with other offenders to commit an offense. Some people may run away even if they see a policeman approaching. That is not conclusive evidence that he had formed an agreement with some other criminals to carry out an unlawful purpose or to commit a crime. There are two types of conspiracy. There is a will type of conspiracy. Now, in this kind of conspiracy, there is a mastermind. And it is the mastermind around whom the entire conspiracy revolves. The mastermind is the one who recruits all the other, conspirators. Like in the case of Njomen and the state, there was a mastermind who was the brain behind the offense, and it was the one that got all the other offenders, to meet in his house and to discuss the details of the offense, to which all of them agreed. So that is a real type of conspiracy. There's a mastermind around whom the wheel of the conspiracy revolves. There's also the chain type of conspiracy in which A recruits B, B recruits C, C recruits D, and maybe D recruits E. Now you have about 5 persons involved in the conspiracy. Now, in this kind of conspiracy, it is even possible for the parties not to know one another. C may not be known to A. A may have recruited B with the agreement that B should go ahead and recruit any other person to join in the conspiracy. And B may have recruited C. And C may have recruited D. Now, in a chain kind of conspiracy, it is not required that all the parties know one another or even have met one another. It is not a requirement. What is important is that any 2 of the parties in the chain must agree to carry out the offense or a part of the offense. So if there was supposed to be a robbery of a bank, and A recruits B, who is a bank staff, who is going to leave the door of the vault of the bank unlocked. Okay? And A recruits C, who is going to be the driver who would drive the getaway car. Okay? And C recruits D, who is the one that will supply A with weapons to enable them effect the robbery of the bank. Now, in this kind of scenario, like I said earlier, it is not required that all the parties know one another or have met one another before. What is important is that between each group of 2 parties, there must be an agreement to carry out part of the alleged offense. Okay? In this case, A, the mastermind, recruited B, the bank official, to leave the door of the vault unlocked. And then A recruits C, an expert driver who will drive away, who will drive the getaway car. Now, C is not known to B, the bank official. There's no agreement between C and B, but there's an agreement between A and C in relation to the same conspiracy. Now, D is the one that supplied A with a weapon, with a gun, for A to use when he enters the premises of the bank. Now, D is not known to B. D is not known to C. There's no agreement between D and B and C, but there's an agreement between D and A. The agreement between D and A relates to the provision of the weapon to A, to enable A in carrying out the conspiracy. So what is important is that between any 2 of conspirators in a chain conspiracy, there must be an agreement that relates to the main offense. Once there is such an agreement, then there is a chain conspiracy. You can see the case of State and Odu. Now, in either type, it must be proved that each accused has agreed with another guilty person. That's all I've been explaining. In either type, it must be proved that each accused has agreed with another guilty person in relation to that single conspiracy. So you can see the case of R against Adalan. And that's the point I've explained now. A, the mastermind in the plot, in the conspiracy to rob the bank, recruited B, the bank official. There is a conspiracy, there's an agreement between A and B relating to the bank robbery. A recruited C, an expert driver to drive the getaway car. There's an agreement between A and C. There's no agreement between B and C. A, the mastermind, recruited somebody that provided the weapon. That is D. There's no agreement between D and C. There's no agreement between D and B, but there's an agreement between A and D in relation to the conspiracy of robbing the bank. So all of them can be charged with the conspiracy relating to the robbing of the bank. So that's how a will conspiracy and a chain conspiracy operates. Now, the second element or ingredient in the offense of conspiracy is the parties. So the agreement must be proved, but the other party need not be identified. Of course, the agreement must be proved. It must be shown that A agreed with B, okay, or he agreed with some other person. But the other party need not be identified. All that needs to be shown is that there is some form of an agreement with some other person, even if the person can no longer be found or the identity is not, clearly revealed. But once it can be shown that there was an agreement with some person, even if not clearly identified, then the requirement of parties will be satisfied. You can see the case of R and Phillips. Now, agreement with certain persons may not suffice to establish the offense of conspiracy. For instance, the sole director of a company. A sole director of a company cannot be charged with the company for a conspiracy, because although the company has a separate legal personality of its own, the sole director is the directing mind and will of the company. So it cannot conspire with the company. It cannot conspire with the company because it is the sole director that will supply, who is the directing mind and will of the company, that will even supply the mental element requirement that may be required in a particular offense. So agreement with certain persons may not suffice to establish the offense of conspiracy, e.g., the sole director of a company. A sole director of a company cannot be charged with a conspiracy with the company with a view to making the company the second party in the agreement. It cannot work. You can see the case of R. and McDonnell and the case of FRN versus Ipe. But where a director conspires doing the company's business with other persons or companies, then the company may be charged as a party to that conspiracy. So where a director conspires during the company's business with other persons or companies, then the company may be charged as a party to that conspiracy. Even the director himself may be charged as a party to that conspiracy. Okay, the director and his company, on whose behalf he transacted, he agreed with another person or another company to carry out what constitutes an offense, they may be charged with that offense. You can see the case of R versus ICR College. Now, where the only party to an agreement are husband and wife, they cannot be guilty of conspiracy. The case of Moji against R, where the only party to an agreement are husband and wife, they cannot be guilty of conspiracy. And the rationale for this under the common law is that the husband and wife are deemed to be one person. And because they are one person, then they cannot be charged for a conspiracy involving them alone. Now, however, a husband and wife can be convicted of conspiracy where a third party is also involved or where the agreement was entered into before the marriage. So where a husband and wife agrees with a third person to commit an offense, then they can both be charged with that other person with the offense of conspiracy, or where the agreement was entered into before the marriage, because before the marriage, the Lord did not take them to be one person. You can see the case of R and Trustee. Now, Section 34 of the Criminal Code on conspiracy between husband and wife. Section 34 of the Criminal Code, is the one, is a provision that provided for the fact that a husband and wife cannot be convicted of a conspiracy between them alone. That was the criminal code that was received into Nigeria. But two of the states in southern Nigeria that has moved away from the provision of the criminal code has removed this provision from their criminal law. And the rationale for this is not difficult to understand. Like I said at the beginning, when we looked at the policy justification for the offense of conspiracy, when two people put their minds and intellect together, society is exposed to greater risk of criminal harm. Now, where the two persons who enters into an agreement to commit an offense are husband and wife, then we can even see that the harm to which society is exposed is even greater, because there is a commitment based on love between husband and wife, which makes them to be even more committed to whatever criminal enterprise that they are both agreed to, compared to an agreement to commit an offense between A and B who have no relationship of husband and wife between them. So the more reason why there's even a stronger argument for the law to criminalize conspiracy between husband and wife. That legal fiction of oneness between husband and wife cannot stand in the face of the risk that the society is exposed to when a husband and wife bounded and bonded together by the ties of love and commitment. And they now extend that tie and commitment to the realm of committing an offense. We can see that the society is at a greater risk of a criminal harm coming from their joint enterprise. So this provision, Section 34 of the Criminal Code, has been removed from the Criminal of Lagos 2011 and from the Criminal of Edo State 2022. And that is the justification for the removal, which I've just explained. If A is charged with conspiracy with B, and B is acquitted, can A be convicted? Now, the question is simple. Two people are charged with conspiracy. Is it possible for one to be acquitted and for the other to be convicted? The case of DPP and Shannon provided an answer to that. And the answer is, it is possible for one to be acquitted and for one to be convicted. Why? Because one of them may have confessed to the offense. If A is charged with conspiracy with B, and A confesses to the offense of conspiracy, it makes a confessional statement. He has repented from his sins and from his wicked ways, and he wants to make peace with God. So if he feels the best thing for him to do is to confess, and he confesses to the authorities, the authorities can use that confession against him to secure his conviction. And under the rules of the law of evidence, that confession by A has no probative value against B. If B denies being part of the conspiracy, and there is no evidence, to support the charge that B was involved in a conspiracy with A, the court may not have any evidence to sustain the conviction of B. So it is possible where two people are charged together for the offense of conspiracy, for one person to be convicted of conspiracy and the other person to be acquitted. That was the decision in the case of DPP and Shannon, the English case of DPP and Shannon. And that is also the position in Section 5(8) of the Criminal Law Act of 1977. That is an English act which, reaffirmed the position that, yes, it is possible where two people are charged with conspiracy for one to be convicted and the other to be acquitted. The third element or ingredient in the offense of conspiracy is the unlawful purpose. Section 516 of the Criminal Code, 516 of the Criminal Code, provides that it is an offense to conspire to commit a felony, or under Section 517, to conspire to commit a misdemeanor. See Section 518 of the Criminal Code for the list of other circumstances which render an agreement a conspiracy. Section 518, subsection 6, makes it a conspiracy to simply conspire with another to effect any unlawful purpose. So if you conspire with another to effect any unlawful purpose, that is conspiracy. The word unlawful is, however, not defined in Section 518, subsection 6. In England, unlawful in relation to conspiracy is used in a wide sense to cover all crimes and some thoughts. But in Nigeria, unlawful should not be construed to include thoughts, because in Nigeria, a person can only be punished for an offense defined in a written law. A wrong under a thought is not a wrong defined in a written law. So it is suggested that the word unlawful should not be construed in Nigeria to include thoughts, because in Nigeria, a person can only be punished for an offense defined in a written law. In a charge of conspiracy, it must be shown that what was agreed to be done constitutes a crime in law. What the parties agreed to do must constitute a crime. In Otegeri versus Inspector General of Police, Oyama J. held that there was no conspiracy because what the accused agreed to do did not disclose any offense. So for the prosecution to be able to sustain a charge of conspiracy, they must show that what the parties have agreed to do constitute a crime under the law. Can a defendant charged with conspiracy and substantive offense be convicted of conspiracy and acquitted of the substantive offense? A defendant who is charged with conspiracy and the substantive offense, can he be convicted of conspiracy and charged and acquitted of the substantive offense? Now, usually, let me illustrate with the offense of murder. If two or more persons agree together to kill their victim, the three of them can be charged with conspiracy. And if they went ahead to carry out their unlawful purpose by killing the victim, they can still be both charged with the offense of conspiracy to commit the offense of murder, and they can also be charged in the same trial with the offense of murder. So the question now is, a person who is charged with conspiracy to murder and charged with the substantive offense of murder, is it possible for a person, for one of them to be convicted of conspiracy to murder and not to be convicted for the substantive offense? Again, the answer to that is provided in the case of R and Cooper, the English case of R and Cooper, and the recent Nigerian case of Balogun versus Attorney General of Ogun State. The answer is that a person who is charged with conspiracy and the substantive offense can be convicted of conspiracy and acquitted of the substantive offense. The prosecution may be able to prove conspiracy, but for some technical reasons, they may not be able to prove the substantive offense. So if they're able to prove the conspiracy, then the offender can be convicted for the offense of conspiracy. The offender can be convicted for the offense of conspiracy. Let me give an example. Now, in a charge of murder, the offense of murder involves where A intends to kill B or where A intends to inflict grievous bodily harm and death results. Okay, so if three people conspire together to kill their victim, and there is email communications between them evidencing the agreement, okay, and they proceeded to carry out the act in pursuance of the agreement, one of them used a cutlass to cut the victim on the head. And after and the victim was injured, he was taken to the hospital, he was being treated in the hospital, he was discharged from the hospital, and then some other medical complications, which is not very clear whether it can be traced to the injury or to some other medical causes not connected with the injury, later, occurred. And it is not very clear whether it was the injury inflicted on the victim that caused the death, or whether there are some other medical complications not connected to the injury that caused the death. Now, in that kind of a situation, for the prosecution to be able to sustain the substantive charge of murder, they must lead evidence to show that it was still the injury that caused the death, or it was medical complications arising from the treatment of the injury, which was proper in the circumstances and was not negligent, that caused the death, before they can succeed in a charge of murder against the accused persons. Now, let's assume that the prosecution did not do its case properly. They did not leave any medical evidence as to the cause of death. They merely charged them for conspiracy and for murder. Now, it is likely that the offenders may get off on the substantive charge of murder because the prosecution failed to lead credible medical evidence to establish that it was the act of the defendants that actually resulted in death, because there was uncertainty as to what actually caused death. So in that kind of a situation, because there was already evidence, documentary evidence of email exchanges where the intention of the parties and the agreement to kill the victim is clearly revealed, the court can convict them on the charge of conspiracy to murder, but may not be able to convict them on the substantive charge of murder. So that establishes the fact that, yes, it is possible when a person is charged with conspiracy and a substantive offense, for the court to convict him on the charge of conspiracy and acquit him on the substantive charge. For the offense of conspiracy under the criminal code, under the penal code, you can see the provisions of section 96 of the penal code and the case of Shurumo versus the state. The case of Shurumo versus the state. One issue that also has to be examined, as part of the elements or ingredients of the offense of conspiracy is the issue of impossibility in conspiracy. Now, we need to note that the criminal code provides no guide on the effect of impossibility. In other words, if parties agree to carry out an act that is not possible in reality, maybe, for instance, they conspire to kill somebody who is already dead. Unknown to them, the person they are conspiring to kill was already dead at the time they were entering into the agreement. And the law enforcement authorities have clear evidence of their conspiracy. So what will happen in that kind of a scenario? Now, it appears, and I've said, the code is not very clear. There's no clear guidance in the criminal code, and there's also no clear guidance under the penal code as well. Now, it appears the distinction at common law between legal impossibility and physical impossibility in relation to attempt will also apply. Remember our discussion on the distinction between legal impossibility and fiscal impossibility in relation to the law of attempt. You know, and we said that where the impossibility is a legal impossibility, then there can be no attempt. But where the impossibility is a fiscal impossibility, then there may still be attempt. In Otegeri versus IGP, Oyama J held that there was no conspiracy because what the accused agreed to do did not disclose any offense. So if what the parties agreed to do did not disclose an offense, in other words, is not legally an offense, then there can be no conspiracy. And this principle was recently reaffirmed in the recent case of Pekolomo against the state. That's a 2021 Nigerian case. And you can see other cases on that point as well. Nanji and IGP and DPP are not. But so the resolution of that is that if the impossibility is a legal impossibility, if the parties agree to do what is legally impossible, then there can be no conspiracy. A person may be convicted of conspiracy to commit a crime of which he could not, if he stood alone, be convicted. That's like an exception to the legal impossibility rule. Because in this case of Majekodumi and now, the appellant, who is a lawyer, was convicted of conspiracy with other defendants who were officials of the Department of Post and Telecommunications to steal postal matter. It was a conspiracy to steal a postal matter, like, you know, a letter or a registered letter. And the argument of the appellant was, look, under the law, I cannot be convicted of stealing a postal matter because I'm not a post office employee. But the court said that, well, while that may be true, because the offense of conspiracy lies only in the agreement and not in the carrying out of the act. Here, you are being charged with agreeing to steal a postal matter. You have not been charged with stealing a postal matter. Because you have been charged with agreeing to steal a postal matter, you can be convicted of that offense, even though you cannot be convicted of stealing a postal matter because you are not a postal officer. So that case established the principle that the person may be convicted of conspiracy to commit a crime of which he could not, if he stood alone, be convicted. If he alone was charged, there was no way he could have been convicted of stealing a postal matter because he's not an officer of the Post and Telecommunications. The Criminal Code also provides for specific cases of conspiracy. There is conspiracy to commit treason under Section 37(2). There is conspiracy to bring false accusation, Section 125. Conspiracy to pervert the course of justice, Section 126, sub 1. Conspiracy to defile a woman or girl, Section 227. And conspiracy to murder under Section 324. And conspiracy to defraud under Section 422. That is the end of the presentation on conspiracy. So I expect that you will listen to the lecture. And if you have questions or you have any request for clarification concerning any aspect of the lecture, I will be, available to make those clarifications or to respond to your questions. Please remember to subscribe to my YouTube channel so that as soon as I post future presentations, you will have immediate access to it. Thank you very much. God bless you. And in the spirit of the season, I wish you Merry Christmas and Happy New Year in advance. God bless.